So we've been focusing a lot on the Illinois Supreme Court ever since the Macon County judge declared the state's gun ban unconstitutional in a final judgment, and plaintiffs in that case saying that that is good statewide. The Attorney General and the governor saying that's not true. However, Illinois State Police, when I asked for if they're enforcing the state's gun ban, they said that they're following the various court rulings and they're taking guidance from the Illinois Attorney General. This is all last week, by the way. I asked the Illinois Attorney General for that guidance. They didn't respond. Asked them again, didn't respond. So I do have a pending Freedom of Information Act request for that guidance post the Macon County decision. But that's the Macon County case. That's not the three other cases that there were filed on the state level court circuit from Attorney Thomas DeVore, and those cases are also ongoing and have their own trajectory. And to talk about an update of that and other issues, I'm joined now by Attorney Thomas DeVore. Thank you for taking time with us this morning. Let's just go ahead and get right on into it. I guess give us an update where we at on those three cases, a possible amendment, and what can you tell us?
Well, the three cases, as you're aware, we consolidated those into Effingham County, Greg, and in that consolidation, there was a request to also consolidate the Macon County case. And for procedural reasons, the governor and the attorney general, and, I'm not criticizing them because if I was them, I would have made the same arguments that they made, said that case was distinguishable and should be left separate. And really what they were trying to accomplish is to keep me away from Caulkins and his lawyer because they were getting everything they wanted out of Dan and his lawyer, and they didn't want me meddling with that. So our cases are separate. Now, since the Macon County case is now proceeding to the Supreme Court and our cases are separate, now the Attorney General and the other defendants want to try to convince the judge in Effingham to not allow our case to proceed while they're in front of the Supreme Court because they're scared to death to answer the discovery requests that I've asked because it's going to uncover a lot of inappropriate things in the legislature, which was what they've always been trying to keep from happening. That's been their major goal. So, we'll argue that on the 21st of March, but I'm extremely hopeful that the judge in Effingham doesn't allow what is clearly a game by the defendants not wanting to proceed in our case because they don't want us uncovering what we know we're going to uncover, which is that, their arguments about training, et cetera, are a completely made up set of circumstances. So, but we'll argue that and see. But that's what's going on in Effingham.
Talk a little bit more, if you can, about that discovery process and what kind of steps are there. I know the Sheriff's Association wanted to quash a subpoena. Who else do you have subpoenas pending out there? Have you gotten anything back yet? And how are those processes playing out in the courts?
No, we've got a little bit back from one of them. I don't recall which one. I did the Illinois Department of Corrections. I did the Illinois Sheriff's Association. I mean, look, Greg, I know from talking to people that are involved in those processes what happened. I know that training had nothing to do with these exemptions. I know it was political. I've talked to people very high up the food chain. But I can't go into court and say that, right? That's not how courtrooms work. So I've subpoenaed the people and the organizations that I know will uncover the games that were going on. I already know the answers, and that's why they're fighting so hard to stifle this discovery process, because they know I'm going to uncover and show the public what I already know had happened. So, the way the discovery works is I sent all these subpoenas. I sent requests for documentation to the governor, to the attorney general, or not the attorney general yet, the legislature, and they do not want to answer those questions because there's a bigger issue going on here, Greg, than this gun bill. And that's what Caulkins and his lawyer don't understand, is the bigger issue is putting an end to the way that our legislature plays games and passes laws without following constitutional procedures. They cannot afford to have that stopped by the Supreme Court of Illinois, and they are pulling out all the stops to try to keep me from accomplishing that. They're willing to lose this gun bill fight. If they do, that's great. But what they don't want to do is lose the way that they pass laws, and we could talk about that more. And that's why they were so desperate to keep Caulkins' case separate from ours, because they know what I'm going after. Dan's not smart enough to understand that, and so they're like, oh, let's go fight the gun bill in the Supreme Court. because the governor and the attorney general and the legislature, the gun bill is secondary to them. More important is the way they pass the laws, and they don't want that stopped, and they're willing to do anything to keep that from happening.
Attorney Thomas DeVore with us, and I do want to talk about the three readings rule and the single subject and the due process issues, which, listen, as a reporter who watches this stuff and all of the thousands of shell bills that get filed and just pushed through committee with the marked out, and then it's replaced with and then they go back later on and grab that and gut and replace. I do want to talk about that a bit, but to the idea of the Caulkins case possibly interfering with your case, even if the Caulkins case is dismissed by the Illinois Supreme Court, how does that impact your case? Wouldn't you still have that ability to take the case forward to the Illinois Supreme Court?
It depends, Greg. It depends upon what the Supreme Court does with Dan's case. And I'll file an amicus brief in that, because I suspect with what I've seen so far, with the very little effort coming out of the plaintiffs in the Macon County case, I'm going to have to file something because they're not doing any work. But depending on what the Supreme Court does with the equal protection argument, because that's the only argument that the Macon County case is taking to the Supreme Court, which is the gun issue on equal protection.
But also special legislation, which I think is somewhat similar. Is that right?
What's that? Yeah, special legislation is almost identical to equal protection. It's not even really distinguishable. But these procedural constitutional issues are not going to the Supreme Court. Now, when a judge in a circuit court deems a statute unconstitutional, that is a mandatory appeal to the Supreme Court. They have to hear that, okay? So the way that I had our cases set up is that I knew equal protection was going to be found by the circuit court. That's why I was building the case on the procedural constitutional issues of three readings, et cetera, because when our case then goes to the Supreme Court, they have to hear both of those issues. Well, now it potentially could be that if the Supreme Court addresses equal protection in a way that forecloses my clients from being able to continue with that argument, I could still continue to argue my three readings violation, but it's not a mandatory appeal to the Supreme Court. They could choose not to hear it, which is the risk that's being taken now, and it's exactly what the governor and the attorney general were trying to accomplish. They want to keep me out of the Supreme Court on the three readings rule, especially, and using Dan was a tool to try to help them accomplish that.
We're talking with attorney Tom DeVore here on Springfield's Morning News. I'm Greg Bishop, now 747. Want to get your take a little bit more on the procedural issues here. You've touched on it several times. And, of course, I think that we're going to see not necessarily it argued in the courtroom today when it comes to the Safety Act and the Pretrial Fairness Act. But how do you see this happening? And is it possible that we could actually get to a true due process of passing legislation to where it's not last minute, waive all the rules, let the legislature waive all the rules with the majority vote, and just continue to do those midnight runs and pass legislation in the last minute? How can we get to actually some semblance of order there?
Well, you see, Greg, that's what I was doing. And I had a 100% certain chance to put that issue in front of the Supreme Court with this gun bill. It was guaranteed I was putting that issue in front of them. And I was going to put that issue in front of them with a record that was so complete that the Supreme Court would have been in a position to only be able to do two things. One, strike it down and say you can't do this anymore, which I think we would have had a high probability. Or two, finally tell the people of Illinois we're never going to strike it down and they can do this stuff forever as long as they want. They would have been put in that position, and I would have really liked the chances of people. Again, I had 100% chance certainty of getting there. That's what scared the governor and the attorney general and the legislature, and again, I got to repeat it because it's important people understand. That's why they went and cut a deal with Dan, because now that case only has equal protection in front of them. So again, can I still get it there? Maybe. But again, we had 100% chance, Greg, before. Now I don't know what our chances are. It just depends on how bad the Macon County case is screwed up when it's in front of the Supreme Court.
Tom, finally here, last week I asked the governor to explain his $1 million donations to two then Supreme Court justice candidates who are now on the bench of 7. And he said it's ridiculous to assume that they should recuse themselves, that they are independent justices, and kind of brushed it off as a right-wing concern. Your reaction to that and just the whole idea of, the integrity of the judiciary?
Well, again, the integrity of the judiciary is everything, and we have to always make sure that the appearance of the integrity is there. The governor's comments were, political fodder. Some of the commentary coming from people talking about the contributions to these justices is political fodder, too. There's a reality in the judiciary, Greg, that people need to understand, is that it does have a political tenet to it, right? Everything's not law and order like you see on television. So when you have judges elected that have received significant financial contributions, does that make them, so biased that they can't hear a case? I'm not willing to say that. But what I am willing to say is that all things considered equal, right down the middle, does that influence people's behaviors and decisions when they've been supported like that? It certainly could, right? Does that mean that these folks need to recuse themselves? Well, think about that. You have two justices, one from the Second Circuit or Appellate District, and you have one from the Third. And then you have two Republicans in the Fourth and Fifth. If these two Supreme Court justices from the Second and the Third recuse themselves, we're left with 3 Democrats from Cook County and 2 Republicans from the Fourth and the Fifth. Is that a better set of facts than leaving all 7 of them there, and at least the ones from the Second and the Third being from a little bit more neutral political districts than Cook County? I mean, it's not so easy to just say, recuse yourselves. You might get a worse set of circumstances than if they stayed. So people need to be careful with that. But all in all, what lawyers need to do, like me, is understand that reality and put the best case you possibly can in front of the court with the most complete record that you can put together, and hammer your case to the point that even if you have justices who have leanings one way or the other, you can overcome that by having a really strong case. And that's where Dan and his lawyer messed up, is because their case is the weakest one that we could ever put in front of them on these issues.
Tom, I got less than a minute here. React to the idea that the Macon County case is statewide. Have you heard from others across the state that are having enforcement actions taken against them? Your reaction in less than a minute, if possible.
Yes, yeah. If you hear Tom DeVore and Kwame Raoul and J.B. Pritzker agree on something, you better listen, because that doesn't happen. The governor and the attorney general are absolutely right. That decision out of Macon County does not create any kind of statewide injunctive relief on this law. It's just a finding of unconstitutionality that takes it to the Supreme Court. There was no injunctive language even in the order, because the attorney general drafted the order, not even Dan's lawyer. And there are enforcement actions going on right now across the state. They call me, and it's not my clients, because as you know, Greg, I've got over 7,000 clients that actually have real injunctions in place. They can't be touched by this state, and they're not. But people are at risk if they listen to Dan Caulkins and that nonsense. And if you actually look now at the Illinois State Rifle Association, they've recanted their position. They shouldn't even be talking about it at all, and said now, you could be charged with a crime. So please, people, don't listen to this statewide injunction stuff. It's not true. That the attorney general and the governor are correct.
Appreciate your time as always. Tom DeVore, attorney. We'll definitely be talking again in the near future. All right, be safe.
Thank you. Take care, Greg. Bye.
It is Springfield's Morning News, now 7:53.
It's time to apply at